the consent is questionable under the circumstances under which my client found himself in. This very trooper even stated that my client wasn't even in a position to give a field sobriety test. He had put into the ambulance, taken to a hospital emergency room. He's in a hospital bed.
That doesn't answer my question. Court does call the case of the people state of Michigan versus Mario Cato.
Good morning, Your Honor. May it please the Honorable Court Jermaine Work P5435 on behalf of Mr. Cato, who stands to my immediate right.
Your name?
Mario Cato.
Thank you. Okay, what are we doing?
This will be an exam, Your Honor.
Okay.
Yes, Your Honor. We will move to sequester any witnesses pursuant to People versus Lindsay.
All right. Witnesses are hereby ordered sequestered. The officer in charge may remain in the courtroom.
Thank you, Your Honor. The only person I have present in the courtroom is Trooper Crystal. He will be my one and only witness.
All right, very good.
And if I may call my first witness?
You may call him.
Thank you. Or can I call me Trooper Crystal?
Sir, please come forward to be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God. Let have a seat. State and spell your personal last name for the record, please.
Dustin Pizzel, it's T-U-S-T-I-N, last name Susie Charlie E-L.
May I inquire?
You may.
Thank you. First, I apologize for mispronouncing your last name. Thank you
Right, that's
I apologize. Thank you. Trooper, where are you currently employed?
with Michigan State Police out of Brighton Hills.
In what capacity?
As Michigan State Trooper,
For how long have you been employed as such?
about 5 years.
Were you working in your capacity as a trooper on July 2nd, 2023?
Yes, I was.
On that date, were you working in the area of M14 in Superior Township, Washtenaw County, Michigan?
Yes,
What took you out to that location?
I was dispatched to a unknown crash, which turned out to be an injury rollover crash on M14 near Fort Road.
Approximately, if you recall, approximately what time of day was it when you were dispatched out there?
It was about 1900, so about 7 o'clock in the afternoon.
Thank you. Did you have the opportunity to arrive on scene?
Yes, I did.
When you arrived on scene, can you please describe for the court what you observed?
So when I was on scene, there was a median M14. There was a red Buick Regal that had severe disabling damage to it. The Superior Township Fire Department was on scene as well as HVA, and they were providing treatment to two occupants of the vehicle, one female and one male, who were both outside the vehicle at the time.
How far outside of the vehicle were they when you observed them?
Oh, I couldn't give you an exact distance, but they were a good ways away from the vehicle.
When you did you have the opportunity to make contact with both the male and the female?
On scene, no, because both of them were transported to the hospital by HVA, but I made contact with both of them at the hospital.
Let's talk about on scene. Did you have the opportunity to observe them on scene?
Yes, I did.
Let's talk about the male specifically. Was he transported to the hospital?
Yes, he was.
How was he transported to the hospital?
So he was still in a walking condition. He was able to be walked to the ambulance and escorted from there. He had some lacerations to his face and everything like that. He complained of like head, neck, chest pains from the crash.
Did you participate at all in helping him get medical treatment, calling HVA out or helping HVA in any way?
Like I said, pretty sure HVA was on scene.
Well,
I'm
going to object to be speculating here.
He's answering my question based on his own.
Overruled.
Thank you, Your Honor. And the female, could you please describe for the court what you observed about her?
So she was in no condition to walk at all. Although I didn't talk to her while I was on scene because she was receiving treatment from HVA and the fire department, to me it looked like her right arm and right hip and leg did not look like they were in place.
I'm going to object to be speculating on that.
Well, no, he's saying what he observed. There's no speculation. Overruled. Go ahead.
Thank you. Could you please describe what you saw about her right arm that told you that it was not in place? What did you see?
You may.
Thank you. Trooper, that's the affidavit that I just asked you about, correct?
Yes.
And there's no mention of marijuana in that affidavit, correct? There's no mention of diabetes in that affidavit, correct? All right. You also didn't explore further Mr. Cato's other medical history besides his diabetes that could have caused this accident, did you?
I did not have medical records or any of his prior medical history, so I did not know him.
All right, so you don't know if he had had a closed head injury or anything of that nature that would affect his cognitive abilities?
I did not.
Okay, thank you. And you had a conversation with the other occupant who was identified as Mr. Cato's girlfriend, correct?
Yes.
And in your conversation with her, she didn't mention anything about him using marijuana, did she?
He did not.
All right. In fact, in part of her conversation, she said they had driven all the way from Chicago, correct?
Sustain.
You also did not ask Mr. Cato whether or not he wanted an independent blood test, did you?
Whenever I read his chemical test rights, in the rights, he has the right to demand that a person who's don't choose and administer their own breath or urine test. So it was offered by reading his chemical test rights.
All right. Did you verbally tell him that?
When I read his chemical test rights.
Okay, very well. And you stated when you initially spoke to him, he was not under arrest, correct?
I advised him that he was under arrest, but that he would be left on scene for further treatment.
So how long did you speak with him before you said, during this initial period in which you stated he was not under arrest?
How long did I talk? I don't recall.
Okay. All right. And when was the decision made to place him under arrest?
After my conversation with him, when he admitted that he had been smoking marijuana during his car ride.
As you sit here today, you don't know whether or not he had a diabetic seizure that day, do you?
I do not.
Thank you. Did you know that he actually had gastrointestinal distress before the accident?
Objection to speculation.
Sustain.
He may know, yeah.
Well, the phrasing of your question, I'm going to sustain it. You can rephrase it.
Okay. Do you know if he had any other medical conditions that caused this accident? Okay, thank you. No further questions, Your Honor.
All right. Any redirect? All right, thank you. Step down. Well, you can, Exhibit A is admitted. Thank you, sir. Any witnesses for the defense?
We have no witnesses, Your Honor, this argument.
Do I have a motion?
Your Honor, that's the location behind the information is good.
All right.
We object to the buying over. We would submit that the affidavit for the search warrant that the officer submitted to obtain the client's blood draw does not comport with the law very specifically that requires probable cause to search warrant. Specifically, there's no mention whatsoever in the search warrant, not only about my client being diabetic, but more importantly about there being any type of a substance being involved in this case. There's no mention of THC. There's no mention of marijuana. There's no mention of alcohol. The case law, which is precedential in this matter, is People versus Courts. It comes out in the Michigan Court of Appeals, 1977 case that cited 75 Mich. App 415-254 Northwest 911, basically states that an officer such as Trooper Pitchell secures a search warrant, more or less for probable cause. There has to be some indicia that a crime was committed. The only thing that search warrant mentions is the fact that my client was driving a vehicle.
But counsel, what do I do with the fact that it's because of his diabetic condition that they get the search warrant? But the trooper clearly testified that he consented to the blood draw in any event.
I understand it, but what I'm saying is that the actual search warrant itself is defective because of the affidavit.
Right, but he consented to have his blood drawn.
And I would even submit the consent is questionable under the circumstances under which my client found himself in. This very trooper even stated that my client wasn't even in a position to give a field sobriety test. He had put into the ambulance, taken to a hospital emergency room. He's in a hospital bed.
That doesn't answer my question. My question is what do I do with his consent?
I would state that his consent was not valid under the circumstances, Your Honor.
What proof do I have of that?
Pardon?
I mean, I'd have to speculate that he wasn't in a position to consent. The trooper very clearly testified that he consented to the blood draw, but that because of his diabetic condition, he got the search warrant. What do I do with his consent? If I buy your argument from the get-go, but what do I do with his consent?
My position, Your Honor, is that his consent is not valid, considering the precarious medical position that he found.
All right, go ahead.
That's my argument.
All right, what okay, if that's also the argument, while the search warrant may not contain that, he was placed under arrest, as the trooper testified, because there was an admission on his part to smoking marijuana during the car ride. What should I do with that? Even if I,
The same situation, my client wasn't in a position from the standpoint of his precarious medical to consent to make any type of admission or consent clearly violated of the case law which I'm citing, clearly violated of the Michigan Constitution, clearly violated of his constitutional rights on a federal level, and the case law that supports that as well. Yeah.
I don't know what I have that even gets me there, but okay, I hear your argument. Go ahead.
Thank you, Your Honor. I would ask Your Honor to look at the, not physically look, but legally consider the face of the search warrant within the search warrant probable cause. So when we look at paragraph 3, this is the section of the search warrant that is about whether or not there is probable cause that the above named suspect was the operator of the vehicle. We have clear indication that this defendant was the operator of the vehicle. And in addition to that, the trooper actually went above and beyond not only to identify him as the person driving the vehicle, but also to articulate the driving that would be indicating to us that this person was impaired. The trooper wrote, the defendant was traveling, the witness told the defendant was traveling at a high rate of speed, that the vehicle started listing into the left shoulder from the left lane, that the vehicle then continually listed off the roadway into the median ditch, where the vehicle hit a median turnaround, causing the vehicle to go airborne and overturn multiple times. The front passenger was ejected from the vehicle and the driver was assisted out of the vehicle. Then when I look down at 3D, the probable cause that the above named subject was under the influence of alcohol or controlled substances. That information, that standard language in this form is included in this form because it's indicating to the court that this is an investigation for intoxication. We get to consider that standard language. And the facts that the trooper articulated was that the driver drove the vehicle off the left lane of the side of the roadway, causing the single vehicle to roll over in a crash. Both the driver and the passenger were severely injured. Passenger was ejected from the vehicle. We get to consider whether that type of driving would lead to probable cause that the driver of the vehicle was intoxicated. I submit to Your Honor that it does. Punishing the trooper for not putting information in the search warrant that he did not know at the time that he drafted the search warrant, that's not appropriate. But certainly, for also to go outside of the search warrant as well, I've argued that there is probable cause based on the search warrant alone. Trooper thank you. Also testified that even after the search warrant is done, now for today's argument, that we learn additional facts. The defendant admits that he was driving while smoking marijuana. And so the search warrant itself is based in probable cause. And then for today's argument for bind over, we then get additional facts that lead further to probable cause for today's bind over. So Your Honor, again, at this point, I would ask Your Honor to bind over the information that's written.
If I may elaborate more, the case of People versus Courts that I cited earlier also mentions other case law, very specifically mentions that under a Michigan Constitution, blood alcohol tests are inadmissible under Article 2, Section 10 of the Michigan Constitution of 1908. It also cites the case of Lethal versus Nicky, which is the Michigan Supreme Court case of 1958, 427-93 Northwest 2D 281. Basically, the public policy, there's the right of a security of a person under the Michigan Constitution. Level fines, exclusion of blood test results necessary under the Michigan Constitution, and quite frankly, may be even stricter than the federal standard. Even speaking to the federal standard, Your Honor, for a warrant to be validly issued, the investigating officers must offer sufficient information to support an independent judgment that probable cause does exist for the issue level warrant. The federal case cited there is Whitley versus Warden, U.S. Supreme Court case of 1971, 401 U.S. 560, 564 Northwest SCT 1031. And also People versus Marshall, which was a 1976 Michigan Court of Appeals case. You don't have that here. This officer did not present sufficient information other than the fact that my client was driving a vehicle. It's no crime to drive a vehicle. There was absolutely no information.
No, but there is. Well, but there doesn't have to be specific information in the search warrant that would say this person is under a particular drug. I mean, if we were talking alcohol, certainly there would be certain indicia, but when people are ingesting controlled substances, we have something different, don't we?
Yeah, but there's no mention of that controlled substance.
How can he mention the controlled substance?
Well, even going greater than that, there's no mention in the affidavit of any crime whatsoever being committed to justify in that affidavit, John.
There doesn't have to be a crime, but counsel, what do you do then with paragraph 3C on the affidavit?
For probable cause, there does have to be a crime, Your Honor.
Probable cause to draw the blood?
Yes.
Okay. What do you do with paragraph 3C?
I would need to see it, Your Honor. I actually use my copy. That's what I referenced, Your Honor, about what the eyewitness said. The eyewitness says he saw an accident, Your Honor. He didn't say that he saw anyone consuming marijuana, the influence of marijuana, or anything that relates to what my client is being charged with. Which is part of the reason quite frankly, on my cross-examination, I wanted to take into question about my client's medical conditions in terms of whether or not there's a diabetic seizure.
Yeah, but those are questions. They are not, that's not evidence before me. They're just questions, counsel. I mean, I have nothing, I mean, you could ask if he saw unicorns. That doesn't mean there were unicorns there. I mean, the cold-hearted reality is, unless I have something to base that on, it's something the trooper did not know. That's all it is. But I don't even know if that's true.
What the trooper said he did not know. That was part of his testimony. Yeah.
But he didn't know something that wasn't true, or didn't know something that isn't true.
That he did know something that wasn't true.
But I don't know that that's true. Your question that's my point. Your question just presupposes it. It doesn't tell me that that's true.
Our argument is that it establishes that there's not problem.
I understand your argument. I'm just telling you, I don't have anything before me that says that. I don't have medical before me that says that there was a brain injury or anything else like that, or that there's a gastrointestinal problem. I don't have any of that other than the subject matter of your question, which I can't take to be true.
I would just ask that you take the officer's testimony. The officer's testimony speaks to that.
Anything else?
No, you're not.
Anything else in the table?
Your Honor, just very briefly, because I think Your Honor gets it. This radical driving, this extreme, is probable cause of intoxication.
Yes, and I would agree. I think there's nothing wrong with the affidavit, the search warrant. When looking at the four corners of the document, the specific challenge to the search warrant is that it doesn't mention a drug. Well, it would mention a drug. In fact, even when there is alcohol involved, it typically won't mention that there's alcohol unless the alcohol was found there. There may be certain other indicia that the trooper might observe, which is one of the reasons why there's check boxes. But I don't see anything deficient with the search warrant. I would also indicate that to the extent that one might find the trooper's testimony is that he could consent, that he consented to it. but that because of his diabetic condition, at least it's disclosed by the defendant, that he opted for the search warrant. And so that creates another reason, but I don't see any reason to disallow the blood test result. It then becomes a question of fact as to the levels of the THC and or its derivative in the defendant's system, as to whether or not that caused the impairment or intoxication and then the impairment in the ability to operate the motor vehicle with regard to those levels, but also then the subsequent admission by the defendant that he had been smoking marijuana on the car ride also leads to or factors into whether or not the defendant was impaired at the time. There isn't and has been no dispute that there was a serious injury caused either to the defendant or to the passenger in the vehicle. So for those reasons, the court does believe that the people have indeed sustained their burden and would bind the defendant over to stand trial as charged. As to the Circuit Court Arraignment Council, you acknowledge receipt of the information.
Yes, Your Honor.
Defendant acknowledging receipt of the information. Does your client stand mute or how does your client plead at this
Yes,
time?
he's
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
June 4th at 1:30 before Judge Conti.
June 4th, 2024, 1:30. Pardon?
What was the judge's name?
Judge Conti.
Court calls the case People versus Dorian Ford.
Excuse me. Good morning, Your Honor. Marcia Creech on behalf of Mr. Ford. Mr. Ford, can you please state your name?
Dorian Ford. Hey, what are we doing?
Your Honor, my understanding, Mr. Ford will be tendering a guilty plea to counts 2 and 3 on the complaint before the court. The people would have no objection to him seeking HIDA at the time of sentencing on those. In return for the plea to those 2 counts, the people would dismiss counts 1 and 4.
That's an accurate statement of the plea.
So he's going to plead guilty to counts 2 and 3.
That's correct, Your Honor.
Is he signed in by Rights Room?
I'm not sure, Your Honor. I believe,
Did he do one today?
yes, he can, Your Honor. He can do one immediately. Date, sign your name. Today is 23rd. April 20. Oh, April 4th.
Yeah, have him sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Dorian Ford. Sir, it is this court's understanding that you're going to plead guilty to 2 misdemeanor charges. Is that your understanding?
Yes, sir.
First stated count 2 of larceny, $200 or more, but less than 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than 2,000, that would become the maximum fine. You understand that?
Yes, sir.
It's also this court's understanding that you're going to plead guilty to the charge of breaking and entering a vehicle to steal property, $200 to $1,000. That's also a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than 2,000, that becomes the maximum fine. You understand that, sir?
Yes, sir.
Understand. I do also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you'd be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
Still wish to plead guilty
Yes, sir.
to the charge of larceny, 200 to 1,000. How do you plead?
Guilty.
To the charge of breaking and entering a vehicle to steal property, 200 to 1,000. How do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form today, is that correct?
Yes, sir.
Any question regarding any of those rights? On the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
Yes, I was promised probation.
No, you weren't promised. You were promised HIDA,
I was.
possibly HIDA, but you were not promised probation.
Yes, sir. I'm sorry.
You understand that the promise is that people won't be objecting 2 years being sentenced under HIDA.
Yes, sir.
Any other promises you received?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily of your own free will? And because you believe that you are indeed guilty of this offense?
Yes, sir.
Between the dates of March 1st, 2023 and April 11th, 2023, location of EMU campus, Ypsilanti, Michigan, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty of that offense?
If I may voir dire, Your Honor?
Yes.
Okay, so on those dates, you're on EMU's campus, correct?
Yes, sir.
Okay, and you went into a vehicle and took some property of Isaiah Pelt or LaShonda Ford or Giovanna Morris, is that correct?
Yes, ma'am.
Okay, and then on or about that same date and that time frame, you did enter a Ford Fusion. Is that correct?
Yes, ma'am.
Okay, and that you unlawfully removed property with the value of 200 or 1,000 or less, but less than $1,000. Is that correct?
Yes, ma'am.
I have no further
Were
questions.
there two vehicles
There were two vehicles.
so you went into two vehicles, sir, and took property?
Yes, sir.
And in each of those instances, you took property that the value of that property was greater than $2,200
Yes, sir.
in each of those instances? Okay,
The people are satisfied.
all right, thank you.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea. You have guilty to counts 2 and 3. Counts 1 and 4 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
June 12th at 10 a.m. before Judge Barr.
June 12th, 2024, at what time? 10 a.m. before Judge Barr. Bond in this matter will continue.
Thank you, Your Honor.
Court calls the case of the people versus Julie Bompashon.
Assistant Public Defender Chinasa Carey, I can really, Your Honor, on behalf of Miss Julie Von Paton.
All right.
Julie,
Court, the court does have, state your name.
Julie Von Paton.
Court has before it a plea form that indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon her successful plea to that charge, she's pleading no contest. Upon her successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That is our understanding, Your Honor. That is correct, Your Honor.
May I have her sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you? Hey,
Julie Von Paton.
Ma'am, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
All right. Let me explain 2 things about a no contest plea to make sure that you understand. First thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Counsel basis for the no contest plea.
Potential civil liability, Your Honor.
So to that charge, she's sentenced before Judge Brownwell. I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yeah.
So to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You had signed an advice of rights form, is that correct? Okay. Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Ann Arbor Police Department report for their case number 23-57430. Any objection to the court having reviewed that report?
No objection, Your Honor.
None particularly, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this case will be
May 1st at 9 a.m. before Judge Perry.
May 1st, 2024, 9 a.m. before Judge Perry. Bond will continue. Ms. Rampashong, how was Jersey?
What was that?
How was Jersey?
It was nice being with my kids. Thank you.
You're welcome. You do the same. Court does call the case People versus Lewis Jefferson.
On behalf of the people.
Citizen Public Defender Chenaz Carey, I can rule, Your Honor, on behalf of Mr. Jefferson, who is approaching.
Today's date types up for preliminary examination. It's my understanding that Mr. Jefferson will be elected to waive his right to an examination. I have made an offer, so to speak. Not be filing a habitual notice in this case.
And that is our understanding, and he is correct, Your Honor. Mr. Jefferson would like to waive his preliminary examination.
Is that correct, sir?
Yes, it is.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause the offenses that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People, for the record, also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. The second.
As to the arraignment, we acknowledge receipt of the information. We stand mute and we ask that the court enter a not guilty plea on his behalf and set this matter for a pretrial judge.
Defendant having waived formal reading, standing mute. The court will enter a not guilty plea to both counts. Pretrial in this matter will be set for
June 3rd at 1:30 before Judge Slay Monday.
June 3rd, 2024, 1:30, Slay Monday. Bond continue. And just go. Court call the case of People versus Michael Kyle.
Assistant Prosecuting Attorney Mark Moroso on behalf of the people.
Ms. Gaines, that's who I have on this one.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Kyle.
All right, what are we doing on this?
Your Honor, we have made all necessary attempts to ensure that our victim is present today. However, she's not in attendance. I do have a forfeiture by wrongdoing motion that I have prepared and ready to file today as a result of her not being in attendance today. I have it prepared and I can hand it to your staff immediately as well as send it electronically. I do also want to note for the record that we had previously had a hearing to have the defendant's privileges revoked on the 28th. That was then carried over to the 4th. On the 28th, we adjourned it out and didn't argue that motion, but you revoked his phone privileges pending the hearing that was going to continue over until the 4th. On the 4th, there was no objection to his phone privileges being revoked, and so they shouldn't have been revoked at that time. However, that order was never provided to the jail by the court, and since the 4th, the defendant has made in total 129 calls to family and friends, including his grandmother, who was the one who patched in the victim previously, which was the basis for that motion, which I filed back on the 28th. I have, because of the number of calls, I have not had an opportunity to listen to them all, or frankly, any of them, but I am significantly concerned that what I did listen to back from the 4th was a call between the defendant and his grandmother in which he indicated he knew he was not supposed to have his phone privileges, but that he was going to continue calling because he did have his phone privileges. I'm concerned, and I do, like I said, have the forfeiture by wrongdoing motion. I will say clearly for the record, I did not see any calls to the victim's phone number. So I believe that was successfully blocked by the jail. But because I haven't had an opportunity to listen to the calls, I don't know if his previous methodology of having her patched in was used to continue to contact of any kind.
Got it. Ms. Gaines.
Your Honor, this is the first I've heard of this. Last information I had from Ms. Barroso was that she would be requesting an adjournment so that she could file the forfeiture motion. That's the last information I have. I have not had an opportunity to discuss this with my client. He has indicated that there has been no contact with the complainant. And, certainly that was the primary intention of the order. And he, as indicated previously with Mr. Banas, has no objection to his phone privileges being revoked. Is that correct, sir?
So I'm going to make it very clear. Defendant's phone privileges are hereby revoked. I will set the hearing on the motion for forfeiture by wrongdoing for May 9th, 2024 at 3 p.m. I will adjourn then the defendant's preliminary examination to my following date of May 21st, 2024, 9 a.m. before me. And we'll continue. Thank you.
Your Honor, we did want to
Go ahead.
address bond if we may briefly.
Go ahead.
Your Honor, Mr. Kyle does have a union job that at this time is his understanding continues to wait for him. He also has his own apartment, his own home that he hopes to be able to go back to the job and to maintain that home. He also states, it's also my understanding that he is a parent. We are asking that the court reduce his bond. It's my understanding that it's currently $100,000, 10%. We're asking for it to be a $10,000 cash or surety bond.
Your Honor, just so the record is clear, this is not the only case holding him. He does have a witness intimidation case resulting from his contact with the victim here that is up for PCC on Thursday. In that case, there is an additional $100,000, 10%. We did request $250,000 cash or surety. In that case, here we requested $100,000 cash or surety. The reason for that is because in this particular case, the defendant woke up his victim, who is the mother of his child, by strangling her and threw her to the ground. And then when she tried to call 911, he took her phone, called his grandmother, the person he's been contacting on the jail calls, and his grandmother told the victim not to call 911, which is the basis for count 2 of interfering with electronic communications. At this time, we are hoping that the witness intimidation that's up on Thursday will be able to catch up with the PE in this case, and we can handle it all at once. But I would object to any reduction in bond here.
Motion for bond reduction is denied. Bond will continue. Court does call the case People versus LaShawn Burrows.
Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. LaShawn Burrows, Judge.
Your Honor, last we were here, we began this exam. Sergeant Bradley testified in a Ypsilanti Police Department case. And at this time, Mr. West has not returned. So he was present the first day. We did until I think it was close to 5 o'clock. We adjourned. He appeared the second day and told us in advance that his father was having some type of medical emergency and that he would receive notice as soon as he went to the hospital. He received that notice before he could testify. My office has been in contact with Mr. West today. He indicated that he was going to get tested, and that's why he was not present today. So, Your Honor, at this time, I am not able to continue this exam today.
Yes, I can run.
In your honor, we would be asking for dismissal.
Is this the only thing holding Mr. Burrows?
It's not, your honor, we waived those 2 OWI cases up to circuit court.
And he has bonds on those.
He does have content. And primarily because we weren't able to get the bond situation resolved at this level.
All right. So if I dismiss it, it's gonna be without prejudice. It can come back.
And that's, we understand that, Your Honor.
You understand that, sir? Or, I mean, because my other option would be, given the circumstances, to find good cause to adjourn it out. Give an opportunity after we find out what his testing reveals for the to appear. That's my other option. But if it goes this way, you understand, Mr. Burrows, that you could be subject to arrest again on this case. I'll dismiss this case at this point. That's without prejudice.